भारतीय नागरिक सुरक्षा संहिता 2023 Section 351 Wrongful confinement of a public servant with intent to commit an offence. What this section is about? Section 351 Section 351 deals with wrongful confinement, specifically targeting public servants when the confinement is done with the intent to commit an offence. In simple English, if a person wrongfully confines a public servant and does so intending to commit an offence such as robbery, assault, or corruption-related crimes, then punishment, imprisonment up to 7 years, and fine. Purpose: to protect public servants from coercion or threats, to ensure smooth functioning of government duties. Key points of Section 351 applies when public servant is confined. Confinement is done with intent to commit another offence. Punishable with up to 7 years imprisonment and fine. Stronger protection than ordinary wrongful confinement. Why this section is important? Protects public officials from harassment and intimidation. Deters criminals from using confinement as a tool to attack or extort public servants. Ensures effective functioning of public administration. In short, Section 351 provides that anyone who wrongfully confines a public servant with intent to commit an offence can be punished with imprisonment up to 7 years and a fine. Section 352 Assault or use of force otherwise than on grave provocation. What this section is about? Section 352 deals with minor assaults or use of force that do not arise from grave provocation and are not severe enough to cause grievous hurt. In simple English, if a person assaults someone or uses force on them without serious provocation, then punishment, imprisonment up to 3 months, or fine up to 500 rupees, or both. Grave provocation, like serious anger due to sudden insult, may reduce culpability, but this section covers ordinary, unprovoked assault. Purpose: to punish minor acts of violence, to maintain law and order, to discourage physical aggression. Key points of Section 352 applies to minor assault or force, not caused by grave provocation. Punishable with short imprisonment, fine, or both. Protects personal safety and dignity. Why this section is important? Maintains public order and personal safety. Provides legal remedy for minor assaults. Prevents escalation of minor conflicts into serious violence. In short, Section 352 provides that anyone who assaults or uses force on another without grave provocation can be punished with imprisonment up to 3 months, fine up to 500 rupees, or both. Section 353 Assault or criminal force to deter public servant from discharge of duty. What this section is about? Section 353 deals with situations where someone assaults or uses criminal force on a public servant in order to prevent them from performing their official duties. In simple English, if a person assaults or applies criminal force to a public servant, such as a police officer or government official, while they are performing their lawful duty, then punishment, imprisonment up to 2 years, or fine, or both. Purpose: to protect public servants from obstruction, intimidation, or attack. To ensure smooth functioning of government duties. Key points of Section 353 applies when assault or force is used against a public servant. Public servant must be discharging official duty. Punishable with imprisonment up to 2 years, fine, or both. Acts as a deterrent to obstructing government functionaries. Why this section is important? protects government officials and law enforcement, prevents interference with public duties, maintains law and order, ensures accountability for those obstructing official functions. In short, Section 353 provides that anyone who assaults or uses criminal force to deter a public servant from performing official duties can be punished with imprisonment up to 2 years, a fine, or both. Section 354, assault or criminal force to women with intent to outrage her modesty. What this section is about. Section 354 deals with acts of assault or criminal force directed at women with the intent to outrage their modesty, such as harassment, touching, or intimidation. In simple English, if a person assaults a woman or uses criminal force against her with the purpose of outraging her modesty or sexual harassment, then punishment, imprisonment up to 2 years, or fine, or both. Purpose: to protect women from harassment and assault, to punish acts intended to violate a woman's dignity. Key points of Section 361 applies only to women. Offense involves assault or criminal force. Intent must be to outrage modesty. Punishable with imprisonment, fine, or both. Covers physical or sexual harassment. Why this section is important. Protects personal dignity and safety of women. Deters sexual harassment and molestation. Upholds women's rights under law. Ensures legal accountability for misconduct against women. In short, Section 354 provides that anyone who assaults or uses criminal force against a woman with intent to outrage her modesty can be punished with imprisonment up to 2 years, a fine, or both. Section 355, assault or criminal force to public servant to prevent arrest or detention. What this section is about. Section 355 deals with situations where a person assaults or uses criminal force against a public servant with the intent to prevent them from making an arrest or lawful detention. In simple English, if a person assaults a police officer or other public servant, to stop them from arresting someone or to prevent lawful detention, then punishment, imprisonment up to 2 years, or fine, or both. Purpose: to protect public servants from interference in carrying out legal duties. To maintain law and order. Key points of Section 355 applies when assault or criminal force is used against a public servant. Public servant must be acting to arrest or detain someone lawfully. Punishable with imprisonment up to 2 years, fine, or both. Ensures officials can perform duties without obstruction. Why this section is important. Protects law enforcement officers from obstruction. Prevents criminals from evading justice through force. Maintains discipline and authority of legal processes. Ensures public safety and order. In short, Section 355 provides that anyone who assaults or uses criminal force to prevent a public servant from making an arrest or lawful detention can be punished with imprisonment up to 2 years, a fine, or both. Section 356, assault or criminal force to public servant to disobey lawful command. What this section is about. Section 356 deals with situations where a person assaults or uses criminal force against a public servant with the intent to prevent them from obeying a lawful command issued in the discharge of their duties. In simple English, if a public servant, like a police officer or government official, gives a lawful order in their official capacity and a person assaults them or uses criminal force to prevent compliance, then punishment, imprisonment up to 2 years, or fine, or both. Purpose: to protect public servants from being obstructed, to ensure obedience to lawful commands and maintain public order. Key points of Section 356 applies to assault or force against public servant. Public servant must be exercising lawful authority. Punishable with imprisonment up to 2 years, fine, or both. Ensures officials can enforce law effectively. Why this section is important? Maintains discipline among the public towards officials. Prevents interference with lawful duties. Strengthens rule of law and public order. Ensures accountability for obstructing government functioning. In short, Section 356 provides that anyone who assaults or uses criminal force to prevent a public servant from obeying a lawful command can be punished with imprisonment up to 2 years, a fine, or both. Section 357 Punishment for attempt to commit offences against public servant. What this section is about? Section 357 deals with attempts to commit offences against public servants even if the act is not completed. In simple English, if a person tries to commit an offence against a public servant, such as assault, using criminal force, or obstructing lawful duties, but does not succeed, then punishment: imprisonment up to 6 months, or fine, or both. Purpose: to deter attempts against public servants, to ensure even incomplete offences are punishable. Key points of Section 357 applies to attempts against public servants. Includes acts like assault, criminal force, or obstruction. Punishable with imprisonment up to 6 months, fine, or both. Focuses on prevention and deterrence. Why this section is important? Protects public servants from threats and attempts. Ensures lawful functioning of government. Prevents offenders from escaping accountability by not completing the offence. Maintains public order and safety. In short, Section 357 provides that anyone who attempts to commit an offence against a public servant can be punished with imprisonment up to 6 months, a fine, or both. Section 358 Causing hurt to extort property or valuable security. What this section is about? Section 358 deals with cases where a person intentionally causes hurt to another person in order to force them to deliver property, money, or any valuable security. In simple English, if a person hurts someone with the intention of extorting property or valuables, then punishment: imprisonment up to 10 years, and fine. Purpose: to deter criminals from using violence to extort, to protect personal safety and property rights. Key points of Section 358 involves causing hurt with intent to extort. Applies to property, money, or valuable security. Punishable with imprisonment up to 10 years and fine. Considered a serious offence due to use of violence and threat. Why this section is important? Protects victims from violent extortion. Provides severe punishment to deter criminals. Ensures personal safety and property rights are safeguarded. Strengthens criminal accountability for extortion through violence. In short, Section 358 provides that anyone who causes hurt to another person in order to extort property or valuables can be punished with imprisonment up to 10 years and a fine. Section 359 Wrongful confinement to extort property, money, or security. What this section is about? Section 359 deals with wrongfully confining someone in order to force them to give property, money, or any valuable security. In simple English, if a person confines someone unlawfully, and the purpose of confinement is to extort money, obtain property, or take a valuable security, then punishment, imprisonment up to 7 years, and fine. Purpose: to prevent offenders from using confinement as a tool for extortion, to protect personal liberty and property rights. Key points of Section 367 applies when confinement is used for extortion purposes, covers money, property, or other valuables, punishable with up to 7 years imprisonment and fine. Stronger protection than ordinary confinement, Sections 342, 344. Why this section is important? Protects victims from coercion and extortion. Deters criminals from using illegal confinement to gain benefits. Ensures legal accountability for serious coercive acts. In short, Section 359 provides that anyone who wrongfully confines a person to extort property, money, or valuable security can be punished with imprisonment up to 7 years and a fine. Section 360, assault or criminal force with intent to extort property, money, or security. What this section is about. Section 360 deals with cases where a person uses assault or criminal force against another with the intention of extorting property, money, or any valuable security. In simple English, if a person assaults someone or uses criminal force, and the intent is to compel them to give property, money, or security, then punishment, imprisonment up to 10 years, and fine. Purpose: to deter violent attempts to extort property, to protect victims' safety and property. Key points of Section 367 applies when assault or force is used for extortion purposes, covers money, property, or valuable security, punishable with imprisonment up to 10 years and fine, recognizes seriousness of violence in extortion crimes. Why this section is important. Protects victims from violent coercion, punishes offenders proportionately to the seriousness of the act, ensures personal safety and property rights, deters organized or violent extortion attempts. In short, Section 360 provides that anyone who uses assault or criminal force to extort property, money, or security can be punished with imprisonment up to 10 years and a fine. Section 361, kidnapping from lawful guardianship. What this section is about. Section 361 deals with kidnapping or abducting a minor or person under lawful guardianship without the consent of the guardian. In simple English, if a person takes or entices someone away who is under the lawful care of a guardian or a minor and does so without the guardian's consent, then punishment, imprisonment up to 3 years, and fine. Purpose: to protect minors and dependent persons, to ensure lawful guardians retain control over those in their care, to prevent abduction or illegal influence. Key points of Section 361 applies to minors or persons under lawful guardianship. Act must be without guardian's consent. Punishable with imprisonment up to 3 years and fine. Focus on protection of vulnerable persons. Why this section is important. Safeguards children and dependents from abduction. Protects parental or guardian rights. Ensures legal recourse against kidnappers. Prevents trafficking or coercion of minors. In short, Section 361 provides that anyone who kidnaps or entices a minor or a person under lawful guardianship without consent of the guardian can be punished with imprisonment up to 3 years and a fine. Section 362, Kidnapping from India. What this section is about. Section 362 deals with taking or enticing a person out of India without their consent or the consent of their lawful guardian if a minor. In simple English, if a person takes or entices someone out of India without the person's consent or without the guardian's consent for minors, then punishment, imprisonment up to 7 years and fine. Purpose: to prevent illegal abduction or trafficking across borders, to protect minors and dependent persons from being taken abroad unlawfully. Key points of Section 362 applies to taking a person out of India. Consent of the person or guardian, if minor, is required. Punishable with imprisonment up to 7 years and fine. Focuses on cross-border abduction and human trafficking prevention. Why this section is important. Safeguards minors and vulnerable persons from being taken abroad unlawfully. Provides legal deterrent against international abduction. Ensures parents and guardians retain authority over minors. Supports public safety and national jurisdiction. In short, Section 362 provides that anyone who kidnaps or entices a person out of India without their consent or the guardian's consent for minors can be punished with imprisonment up to 7 years and a fine. Section 363, Punishment for kidnapping from lawful guardianship. What this section is about. Section 363 prescribes the punishment for anyone who kidnaps or abducts a person from the lawful custody of a guardian. In simple English, if a person takes away someone who is under the care of a guardian, like a child, without consent, then punishment, imprisonment up to 7 years and fine. Purpose: to protect minors and dependent persons. To ensure guardianship rights are respected. To deter kidnapping and abduction. Key points of Section 363. Applies to kidnapping or abduction from lawful guardianship. Punishable with up to 7 years imprisonment and fine. Focus on protection of minors and dependent persons. Strengthens legal authority of guardians. Why this section is important. Safeguards children and vulnerable persons. Prevents unauthorized removal or abduction. Provides legal remedy for guardians. Ensures serious punishment for kidnapping. In short, Section 363 provides that anyone who kidnaps or abducts a person from the lawful custody of a guardian can be punished with imprisonment up to 7 years and a fine. Section 364, Kidnapping or abduction with intent to murder. What this section is about. Section 364 deals with cases where a person kidnaps or abducts someone with the intention of killing them. In simple English, if a person kidnaps or abducts another person and the intent is to cause their death, then punishment, death, or imprisonment for life and fine. Purpose: to punish extremely serious crimes. To deter kidnapping with murderous intent. Key points of Section 364. Applies to kidnapping or abduction with intent to murder. Punishment is Section 365, Kidnapping or abduction with intent to commit theft, grievous hurt, or wrongful confinement. What this section is about. Section 365 deals with cases where a person kidnaps or abducts someone with the intention to commit theft, cause grievous hurt, or commit wrongful confinement. In simple English, If a person takes someone away unlawfully and the intent is to commit theft, cause serious injury, or confine them illegally, then punishment, imprisonment up to 10 years, and fine. Purpose: to punish abductions linked to other criminal intentions, to protect victims from compounded crimes. Key points of Section 365 applies to kidnapping or abduction with ulterior criminal intent, covers theft, grievous hurt, or wrongful confinement, punishable with up to 10 years imprisonment and fine, ensures serious consequences for planning multiple crimes through abduction. Why this section is important: protects victims from compounded criminal acts, deters criminals from using abduction as a tool to commit further crimes, strengthens personal safety and law enforcement. In short, Section 365 provides that anyone who kidnaps or abducts another person with intent to commit theft, grievous hurt, or wrongful confinement can be punished with imprisonment up to 10 years and a fine. Section 366, kidnapping, abduction, or inducing a woman to force marriage, immoral traffic, or outrage her modesty. What this section is about: Section 366 deals with cases where a woman is kidnapped, abducted, or induced with the intention of forcing her into marriage, involving her in immoral traffic, or outraging her modesty. In simple English, if a person takes away or entices a woman to compel marriage against her will, or to exploit her sexually, or to outrage her modesty, then punishment, imprisonment up to 10 years, and fine. Purpose: to protect women from abduction and exploitation, to prevent forced marriages, trafficking, and sexual harassment. Key points of Section 366 applies to women kidnapped, abducted, or induced, covers marriage, immoral traffic, and outraging modesty, punishable with imprisonment up to 10 years and fine, aims to protect personal liberty and dignity of women. Why this section is important: provides strong legal protection against abduction and trafficking, protects women from coercion, exploitation, and sexual crimes, deters criminals from targeting women for marriage or immoral purposes, upholds personal safety and dignity of women. In short, Section 366 provides that anyone who kidnaps, abducts, or induces a woman to force marriage, involve her in immoral traffic, or outrage her modesty can be punished with imprisonment up to 10 years and a fine. Section 367, kidnapping or abduction with intent to steal, commit robbery, or commit assault. What this section is about: Section 367 deals with cases where a person kidnaps or abducts someone with the intent to commit theft, robbery, or assault. In simple English, if a person takes someone away unlawfully and the purpose is to steal property, commit robbery, or commit assault, then punishment, imprisonment up to 10 years, and fine. Purpose: to deter kidnapping used as a means to commit other crimes, to protect victims from compounded criminal acts. Key points of Section 367 applies when kidnapping abduction is done with ulterior criminal intent, covers theft, robbery, or assault, punishable with up to 10 years imprisonment and fine, focuses on protection of personal safety and property. Why this section is important: prevents criminals from using abduction as a tool for other offenses, protects victims from physical and financial harm, strengthens accountability for serious criminal acts. In short, Section 367 provides that anyone who kidnaps or abducts a person with the intent to commit theft, robbery, or assault can be punished with imprisonment up to 10 years and a fine. Section 368, kidnapping or abduction of a woman with intent to force her marriage. What this section is about. Section 368 deals with cases where a woman is kidnapped or abducted with the intention of forcing her into marriage against her will. In simple English, if a person takes away or entices a woman to compel her to marry someone, then punishment, imprisonment up to 10 years, and fine. Purpose: to protect women from forced marriages. To punish abduction for coercive matrimonial purposes. Key points of Section 368. Applies when a woman is kidnapped or abducted for marriage. Consent of the woman is ignored or bypassed. Punishable with up to 10 years imprisonment and fine. Protects personal liberty and dignity. Why this section is important. Prevents coercive or forced marriages. Protects women's freedom to choose. Deters criminals from using abduction for matrimonial purposes. Upholds human rights and gender justice. In short, Section 368 provides that anyone who kidnaps or abducts a woman with intent to force her into marriage can be punished with imprisonment up to 10 years and a fine. Section 369, kidnapping or abduction of a child under 10 years. What this section is about. Section 369 deals with kidnapping or abducting a child under the age of 10 years, regardless of the intent behind the act. In simple English, if a person takes away or entices a child below 10 years of age, then punishment, imprisonment up to 7 years, and fine. Purpose: to protect young children from abduction. To ensure their safety and security. Key points of Section 369. Applies specifically to children under 10 years. Kidnapping or abduction is punishable even if no other crime is intended. Punishable with up to 7 years imprisonment and fine. Ensures protection of vulnerable minors. Why this section is important. Safeguards children from abduction and trafficking. Provides legal remedy for parents and guardians. Deterrent against exploitation of minors. Strengthens child protection laws. In short, Section 369 provides that anyone who kidnaps or abducts a child under 10 years of age can be punished with imprisonment up to 7 years and a fine. Section 370, trafficking of persons. What this section is about. Section 370 deals with trafficking of persons, including recruiting, transporting, harboring, or receiving persons for the purpose of exploitation, such as forced labor, sexual exploitation, or other forms of abuse. In simple English, if a person recruits, transports, or harbors another person, using force, threat, or deception, with the intention of exploitation, then punishment, imprisonment of 7 to 10 years, and fine, which may extend to 5 lakh rupees. For repeat offenders, imprisonment may extend to 14 years. Purpose: to prevent human trafficking, to protect victims from exploitation, to punish traffickers severely. Key points of Section 370. Covers recruitment, transport, harboring, or receiving of persons. Intent must be for exploitation, sexual, labor, etc. Punishable with 7-10 years imprisonment, fine, and harsher penalties for repeat offences. Protects victims' human rights and dignity. Why this section is important. Provides strong legal framework against human trafficking. Protects vulnerable persons from exploitation. Deterrent against organized trafficking networks. Supports human rights and justice for victims. In short, Section 370 provides that anyone involved in trafficking persons for exploitation can be punished with imprisonment of 7 to 10 years, a fine, and more severe punishment for repeat offenders. Section 371, Importation of a girl for prostitution. What this section is about. Section 371 deals with bringing a girl into India from another place or country with the intention of forcing her into prostitution. In simple English, if a person imports or brings a girl from any place into India with the intention that she will be used for prostitution, then punishment, imprisonment of 7 to 10 years and fine. Purpose: to prevent trafficking for sexual exploitation. To protect girls from forced prostitution. Key points of Section 371. Applies to importing a girl into India. Intent must be for prostitution. Punishable with 7-10 years imprisonment and fine. Protects girls from sexual exploitation. Why this section is important. Strengthens legal action against trafficking for prostitution. Provides protection to girls from exploitation. Acts as a deterrent to traffickers. Ensures upholding of human rights and dignity. In short, Section 371 provides that anyone who imports a girl with intent for prostitution can be punished with imprisonment of 7 to 10 years and a fine. What Section 372 says, in simple terms. Section 372 applies when a person accused of a crime appears to be mentally sound, of sound mind, during the legal process, but there is evidence that the accused may have committed an act that would have been an offense if the person had been of sound mind and, at the time of committing that act, the person was mentally unsound, meaning they were unable to understand the nature of what they were doing, or that it was wrong or against the law due to mental illness. If both conditions are met, the magistrate shall continue with the legal proceedings against the accused as if no mental unsoundness prevented the act. If the case is serious and needs a higher court's jurisdiction, the magistrate must commit the accused for trial before the court of session. Why this section exists? This provision ensures that a person cannot avoid criminal proceedings simply because they are found to be mentally sound at the time of trial or inquiry, but they committed the act while they were mentally unsound, unable to understand or control their actions. So, the court examines both the mental state at the time of trial and the mental state at the time of the act, and if the act was committed due to unsoundness of mind, the case continues under normal legal procedure. What Section 373 is about? Section 373 deals with judgments of acquittal on the ground of mental unsoundness at the time of committing an offense. It guides the court on how to record its decision when someone is acquitted because they were mentally unsound, unable to understand the act, or that it was wrong or against the law at the time they allegedly committed the offense. In simple terms, if a court finds that a person committed an offense but, at the time it was done, the person was mentally unsound, i.e., could not understand the nature of the act or that it was illegal, the court can acquit the person on that ground. When such an acquittal is given, the judgment must explicitly state whether the person did the act or did not do the act. This is important because the acquittal is not simply stating that the person didn't commit the act, it recognizes that the act may have been done, but that the person's mental condition at the time absolved them of legal responsibility. Key points to remember. Acquittal due to mental unsoundness. The accused is not held legally responsible if, at the time of the act, they could not understand the nature or wrongfulness of their actions, due to mental illness. Court's finding: the judgment must clearly record whether the act was done or not, even though the accused is acquitted on the basis of unsoundness of mind. Why this section matters? This rule ensures clarity in the judgment. Even when someone is acquitted because of a mental condition, the court must clearly indicate the factual situation, whether the act was done, while recognizing the legal effect of mental unsoundness. Bharatiya Nagarik Suraksha Sanhita, 2023, Section 374. Section 374. Order after acquittal on the ground of unsoundness of mind. What this section is about. Section 374 explains what the court must do after a person is acquitted under Section 373 because of mental unsoundness. It focuses on the safety of the accused and the public. Simple explanation. When a court acquits a person because they were mentally unsound at the time of committing the act, the court must then decide how that person should be dealt with. The court has two main options. 1. Detention in safe custody. If the court believes the person is still mentally ill and may be dangerous, it may order that the person be kept in safe custody, such as a mental health facility or any other safe place prescribed by law. This detention is not punishment, but protective care. Though, release on security, bond. If the court is satisfied that the person can be safely cared for by family or friends and the person is not likely to cause harm, the court may release the person to a relative or friend after taking a bond or security. The bond ensures proper care and treatment of the person, prevention of harm to self or others. Important points to remember. The person is not punished because they are legally not responsible due to mental unsoundness. The focus is on treatment, safety, and supervision. The decision depends on medical evidence, nature of the act, possibility of danger to society. In short, Section 374 ensures that after acquittal due to mental illness, the court takes proper steps either to safely detain or responsibly release the person. Bharatiya Nagarik Suraksha Sanhita, 2023, Section 375. Section 375. Procedure when the accused is detained or released under Section 374. What this section is about. Section 375 explains the procedure that must be followed after the court orders detention or release of a person under Section 374, i.e., a person acquitted due to unsoundness of mind. Simple explanation. When a person is detained in safe custody or released to a relative or friend on a bond, the following rules apply. 1. Reporting to the government. The court must report the case to the state government. This ensures official supervision and monitoring of the mentally unsound person. Though, continue detention if required. If the person is kept in safe custody, they will remain there until the state government orders otherwise. Detention continues only for treatment and public safety, not as punishment. 3. Conditions of release. If the person is released on bond, the relative or friend must take proper care of the person, ensure medical treatment, prevent harm to the person or others. If the conditions are violated, the court may cancel the release, order detention in safe custody. Important points to remember. The section focuses on control, supervision, and safety. The accused remains under legal and medical oversight. Detention is not punishment, only preventive care. In short, Section 375 ensures that persons acquitted due to mental unsoundness remain under government supervision, whether detained or released, to protect both the individual and society. Bharatiya Nagarik Suraksha Sanhita, 2023, Section 376. Section 376. Power of state government to discharge or transfer a person detained under Sections 374, 375. What this section is about. Section 376 gives power to the state government to decide what should be done with a person who has been detained in safe custody because of mental unsoundness. Simple explanation. If a person has been acquitted due to unsoundness of mind and detained in safe custody under Sections 374 or 375, then the state government may 1. Order discharge, release, if medical opinion shows that the person has recovered or is no longer dangerous. The state government may release, discharge the person either completely or subject to conditions such as supervision or treatment. Though order transfer, the state government may transfer the person from one place of custody to another. For example, from a jail to a mental health hospital or from one hospital to another better facility. Important points to remember. Decisions are based on medical reports and safety concerns. The aim is treatment and protection, not punishment. Courts do not manage long-term custody. This responsibility lies with the state government. In short, Section 376 allows the state government to release, conditionally release, or transfer a mentally unsound person who is kept in safe custody after acquittal, depending on recovery and safety. Bharatiya Nagarik Suraksha Sanhita, 2023, Section 377. Section 377. Procedure where a person detained is found to be of sound mind. What this section is about. Section 377 explains what must be done when a person who was earlier detained because of mental unsoundness is later found to have become mentally sound, fit. This situation usually arises after detention under Sections 374, 376. Simple explanation. If a person who was acquitted due to unsoundness of mind and detained in safe custody is later examined and found to be of sound mind, then the following procedure applies. 1. Medical certification. A medical authority must certify that the person has recovered and is now mentally fit, though production before the magistrate. After recovery, the person must be produced before the magistrate who dealt with the case or a competent court. 3. Court's decision. The magistrate will then decide whether the person should be released or whether any further legal action is required under law. Important points to remember. Recovery must be medically confirmed. Final decision lies with the court, not only doctors or the government. The focus remains on justice, safety, and legality, not punishment. In short, Section 377 ensures that once a detained person recovers from mental illness, the court reassesses the situation and decides the next legal step. Section 378. Procedure when the accused was of unsound mind during trial and later becomes fit. What this section is about. Section 378 explains what the court must do when an accused person, who could not be tried earlier because of mental unsoundness, later becomes mentally fit to stand trial. Simple explanation. This section applies when, during inquiry or trial, the accused was found mentally unsound and proceedings were postponed or suspended, and later, the accused recovers and becomes of sound mind. Then the law provides the following steps. 1. Medical confirmation. A medical authority certifies that the accused is now mentally sound and capable of understanding the proceedings and defending themselves. Though, resumption of proceedings. Once the court is satisfied about recovery, the inquiry or trial resumes from the stage where it was stopped. The case continues as per normal criminal procedure. Important points to remember. Recovery must be officially certified. The earlier pause was temporary, not permanent. The accused gets a fair trial only when mentally fit, ensuring justice. In short, Section 378 ensures that criminal proceedings restart once an accused, earlier unfit due to mental illness, becomes mentally capable of facing trial. Say next section when you're ready, and I'll explain Section 379 next from the Bharatiya Nagarik Suraksha Sanhita 2023 in the same simple, exam-oriented style. Bharatiya Nagarik Suraksha Sanhita 2023 Section 379. Section 379. Procedure when the accused is incapable of entering defense due to mental or physical condition. What this section is about. Section 379 applies when an accused person is present before the court, but is incapable of entering a defense because of a mental or physical condition, even though the case has otherwise reached the stage of defense. Simple explanation. If the court finds that the accused cannot properly understand the proceedings, or the accused cannot instruct a lawyer or present a defense due to mental illness or serious physical incapacity, then the court must act in a fair and protective manner. What the court can do. Medical examination. The court may order the accused to be examined by a medical expert to assess their condition. Postponement of proceedings. If incapacity is confirmed, the court may postpone the trial until the accused becomes capable of defending themselves. Safe custody or appropriate care. If required for safety or treatment, the court may order safe custody or ensure proper medical care as per law. Important points to remember. The focus is on capacity to defend, not just presence in court. This section protects the right to a fair trial. Proceedings are delayed only to ensure justice and human treatment, not to punish the accused. In short, Section 379 ensures that a criminal trial does not proceed unfairly when the accused is mentally or physically incapable of presenting a defense. Bharatiya Nagarik Suraksha Sanhita 2023 Section 380. Section 380. Release of person of unsound mind pending investigation or trial. What this section is about. Section 380 explains when and how a person who is mentally unsound may be released during an investigation or trial instead of being kept in jail or custody. Simple explanation. If a person accused of an offense is found to be of unsound mind, and the court believes that the person cannot be tried at that time and detention in jail is not necessary or appropriate, then the court may order release subject to safety conditions. How release is allowed. The court may release the person to a relative or friend or to any responsible person after taking a bond, security, which ensures that the accused will receive proper care and treatment, and the accused will not cause harm to themselves or others. Important safeguards. If the offense is serious, the court must be extra cautious. If no suitable person is available to take responsibility, the court may order the accused to be kept in a mental health facility or safe custody instead of jail. In short, Section 380 allows human and conditional release of a mentally unsound accused during investigation or trial, focusing on treatment and public safety rather than punishment. Bharatiya Nagarik Suraksha Sanhita 2023 Section 381. Section 381. Procedure when a person of unsound mind is released on bond. What this section is about. Section 381 explains the safeguards and follow-up procedure when an accused person of unsound mind is released on bond, for example, to a relative or responsible person during investigation or trial. Simple explanation. When a mentally unsound accused is released on bond, the law requires continued supervision to ensure care, treatment, and public safety. Key provisions. Conditions of the bond. The person who takes custody, relative friend responsible person, must provide proper care and medical treatment to the accused and prevent any harm to the accused or others. Court's power to review. If the court later finds that the conditions of the bond are not being followed or the accused's condition has worsened or become dangerous, the court may cancel the bond and order the accused to be taken into safe custody or a suitable mental health facility. Focus on safety, not punishment. Any action taken is protective and medical, not punitive. Important points to remember. Release is conditional, not absolute. Ongoing care and supervision are mandatory. The court retains continuous control to protect justice and society. In short, Section 381 ensures that when a mentally unsound accused is released on bond, strict conditions and court supervision continue, and custody can be changed if safety or care is compromised. Say next section when you're ready, and I explain Section 380 to next from the Bharatiya Nagarik Suraksha Sanhita 2023 in the same simple, exam-friendly manner. Bharatiya Nagarik Suraksha Sanhita 2023 Section 382. Section 382. Procedure when the accused is a person with mental or physical disability and the case is postponed. What this section is about. Section 382 explains what the court should do when a criminal case is postponed because the accused has a mental or physical disability, making it unfair or impossible to continue proceedings at that time. Simple explanation. This section applies when the accused cannot properly understand the proceedings or the accused cannot participate in the trial or defend themselves due to mental illness or serious physical disability. What the court must do. Postponement of inquiry or trial. The court may postpone the proceedings until the accused becomes capable. Care and custody during postponement. The court must decide whether the accused should be released on bond to a responsible person or be kept in safe custody or a suitable medical facility if release is unsafe. Periodic review. The court can review the condition of the accused from time to time. If the accused becomes fit later, the trial can resume. Important points to remember. This section protects the right to a fair trial. The aim is treatment, care, and safety, not punishment. Proceedings restart only when the accused is capable of defending themselves. In short, Section 382 ensures human handling of criminal cases when the accused cannot face trial due to mental or physical disability by allowing postponement with proper care and supervision. Bharatiya Nagarik Suraksha Sanhita 2023 Section 383. Section 383. Procedure when a person with mental or physical disability is capable of making a defense through a legal representative. What this section is about. Section 383 applies when the accused has a mental or physical disability but is still capable of defending the case through a lawyer, even if they cannot personally conduct their defense. Simple explanation. This section ensures that a trial does not stop unnecessarily just because the accused has a disability, as long as their legal rights can be properly protected through a legal representative. Key provisions. Defense through a legal representative. If the court is satisfied that the accused cannot personally defend themselves, but a lawyer can effectively represent them, Then the court may continue the inquiry or trial. No automatic postponement. Unlike earlier sections, postponement is not mandatory if legal representation can ensure a fair defense. Court's duty. The court must ensure that the accused's interests are fully protected and the trial remains fair and just. Important points to remember. Presence of disability stoppage of trial. Effective legal representation is the key condition. The section balances fair trial rights with timely justice. In short, Section 383 allows criminal proceedings to continue when an accused with mental or physical disability can be adequately defended through a legal representative. Say next section when you're ready, and I'll explain Section 384 next from the Bharatiya Nagarik Suraksha Sanhita 2023 in the same easy, exam-friendly manner. Bharatiya Nagarik Suraksha Sanhita 2023 Section 384. Section 384. No order of release if the act committed is dangerous unless proper care is ensured. What this section is about. Section 384 places a restriction on releasing a mentally unsound accused or acquitted person when the act committed was serious or dangerous. It ensures public safety is not compromised. Simple explanation. This section applies when a person has committed an act which involves violence or poses danger to life or public safety, and the person is of unsound mind or acquitted on the ground of mental unsoundness. In such cases, what the court must ensure? The court shall not release the person unless it is satisfied that proper care, supervision, and treatment arrangements exist, and the person will not pose danger to themselves or others. If such arrangements are not available, the court must order detention in safe custody or a mental health facility. Important points to remember. Serious or violent acts, stricter control. Release depends on medical opinion and safety assessment. Protection of society is a primary concern. In short, Section 384 ensures that persons of unsound mind who have committed dangerous acts are not released unless strict safety and care conditions are fully satisfied. Say next section when you're ready, and I'll explain Section 385 next from the Bharatiya Nagarik Suraksha Sanhita 2023 in the same easy, exam-friendly manner. Bharatiya Nagarik Suraksha Sanhita 2023 Section 385. Section 385. Procedure regarding persons detained or released under this chapter. What this section is about. Section 385 lays down general and continuing safeguards for persons who are detained or released because of mental unsoundness under this chapter. Sections 372-384. It ensures ongoing supervision, legality, and human treatment. Simple explanation. This section applies to persons who are detained in safe custody or a mental health facility, or released on bond to a relative or responsible person because of mental unsoundness or incapacity. Key provisions. Regular supervision. Authorities must ensure that the person is properly cared for and medical treatment is being provided. Power to call for reports. The state government or court may call for medical or status reports and review whether detention or release should continue. Change in orders. If circumstances change, recovery, danger, neglect, or violation of bond, the authority may order release or order detention or transfer as required for safety and care. No punishment. Any custody under this section is preventive and medical, not penal. Important points to remember. Focus is on treatment and welfare. Public safety and individual rights are both protected. Orders are reviewable and adjustable, not permanent by default. In short, Section 385 ensures continuous legal and medical oversight of persons detained or released due to mental unsoundness, allowing authorities to modify arrangements as circumstances change. Bharatiya Nagarik Suraksha Sanhita, 2023, Section 386. Section 386, Power of the State Government to make rules for this chapter. What this section is about. Section 386 gives the state government the authority to make detailed rules for implementing and managing all matters covered in this chapter, sections 372-385, which mainly deal with persons of unsound mind or with mental physical incapacity in criminal proceedings. Simple explanation. Because courts and authorities need clear procedures to handle such sensitive cases, this section allows the state government to frame rules on practical aspects like care, custody, treatment, and supervision. What kind of rules can be made? The state government may make rules regarding place and manner of detention, mental health hospitals, safe custody, other facilities, medical examination and treatment, who examines the person, how often, and reporting procedures, release on bond, conditions, responsibilities of relatives or guardians, reports and supervision, periodic medical or status reports to courts or government, transfer, discharge, or continued detention, based on recovery or safety concerns. Important points to remember. These rules must be consistent with the BNSS. The purpose is human treatment, legal clarity, and public safety. Courts rely on these rules for uniform and practical implementation. In short, Section 386 empowers the state government to frame rules to properly implement and manage all procedures relating to mentally unsound or incapacitated persons under this chapter. Bharatiya Nagarik Suraksha Sanhita, 2023, Section 387. Section 387, Judgment. What this section is about. Section 387 explains how a criminal court must deliver its judgment after completing a trial. It sets basic rules about what a judgment should contain and how it should be pronounced. Simple explanation. After hearing all evidence and arguments, the court must give a judgment, which is the final decision in the case. The judgment must be written, reasoned, and clear. Key requirements of the judgment. Points for determination. The judgment should clearly mention what questions or issues the court considered. Decision on each point. The court must state its findings on each issue. Reasons for the decision. The court must explain why it reached that conclusion. Pronouncement. The judgment must be pronounced in open court and signed and dated by the presiding judge. Important points to remember. A judgment cannot be arbitrary. Reasons are mandatory. This ensures transparency, fairness, and accountability. Open court pronouncement builds public confidence in justice. In short, Section 387 requires every criminal judgment to be a reasoned, written decision pronounced openly by the court after the trial concludes. Say next section when you're ready, and I'll explain Section 388 next from the Bharatiya Nagarik Suraksha Sanhita, 2023 in the same easy, exam-friendly manner. Bharatiya Nagarik Suraksha Sanhita, 2023, Section 388. Section 388, Language and Contents of Judgment. What this section is about. Section 388 explains in what language a criminal judgment must be written and what it must contain so that it is clear, understandable, and legally valid. Simple explanation. This section ensures that judgments are written in a proper language and format so that parties understand the decision. Higher courts can review it. Justice is transparent. Key provisions. Language of the judgment. The judgment must be written in the language of the court or any other language officially permitted by the state government. Clear and complete contents. The judgment should include the points for determination, the decision on each point, the reasons for those decisions, conviction details if guilty. If the accused is convicted, the judgment must clearly mention the offense proved and the section of law under which the person is convicted. Acquittal if not guilty. If the accused is acquitted, the judgment must clearly say so. Important points to remember. Language must be official and understandable. Reasons are mandatory, not optional. Proper drafting helps in appeals and revisions. In short, Section 388 ensures that every criminal judgment is written in an authorized language and clearly explains the decision, reasons, and legal provisions involved. Say next section when you're ready, and I'll explain Section 389 next from the Bharatiya Nagarik Suraksha Sanhita 2023 in the same simple, exam-friendly manner. Bharatiya Nagarik Suraksha Sanhita 2023 Section 389. Section 389. Judgment in cases tried by magistrates. What this section is about. Section 389 lays down special rules for judgments delivered by magistrates, especially in less serious cases. It allows shorter and simpler judgments while still ensuring fairness and legality. Simple explanation. When a case is tried by a magistrate, the judgment does not always need to be very lengthy. Instead, the magistrate may deliver a brief judgment, provided it clearly shows what the magistrate must record. The offense. What offense the accused is charged with. The plea of the accused. Whether the accused pleaded guilty or not guilty. The main reasons for the decision. Short but clear reasons for conviction or acquittal. Sentence if convicted. The punishment imposed. Important points to remember. Detailed judgments are not mandatory in all magistrate cases. Even a short judgment must be reasoned and lawful. This saves time and speeds up summary and minor trials. In short, Section 389 allows magistrates to write concise judgments as long as the offense, plea, reasons, and sentence are clearly recorded. Say next section when you're ready, and I'll explain Section 390 next from the Bharatiya Nagarik Suraksha Sanhita 2023 in the same easy, exam-friendly manner. Bharatiya Nagarik Suraksha Sanhita 2023 Section 390. Section 390. Judgment in cases of conviction on plea of guilty. What this section is about. Section 390 explains how a court should record its judgment when the accused pleads guilty and is convicted on that plea. Since the accused admits guilt, the law allows a simpler form of judgment. Simple explanation. If the accused pleads guilty voluntarily and the court accepts that plea, then the court may convict the accused without a full trial. What the judgment must contain. In such cases, the judgment only needs to briefly state the offense. What offense the accused has admitted to. The plea. That the accused pleaded guilty. The conviction. That the court convicts the accused on that plea. The sentence. The punishment imposed, fine, imprisonment, or both. Important points to remember. The plea of guilty must be clear, voluntary, and understood by the accused. No detailed discussion of evidence is required. This helps in speedy disposal of cases. In short, Section 390 allows the court to deliver a brief judgment when an accused is convicted on a voluntary plea of guilty. Say next section when you're ready, and I'll explain Section 391 next from the Bharatiya Nagarik Suraksha Sanhita 2023 in the same easy, exam-friendly manner. Bharatiya Nagarik Suraksha Sanhita 2023 Section 391. Section 391 Judgment in Summary Trials. What this section is about. Section 391 explains how judgments should be recorded in summary trials, fast-track trials for minor offences. Because these cases are simple and less serious, the law allows a very brief form of judgment. Simple explanation. When a case is tried summarily, in a quick and simplified manner, the court does not need to write a detailed judgment. A short written record is sufficient. What the magistrate must record. The judgment in a summary trial should briefly state the offence, what offence the accused was charged with, the plea of the accused, whether the accused pleaded guilty or not guilty, the finding, whether the accused is convicted or acquitted, the sentence, if convicted, the punishment awarded. Important points to remember. Detailed reasons are not required, unlike regular trials. The aim is speedy justice for minor offences. Even a brief judgment must be clear and lawful. In short, Section 391 allows very concise judgments in summary trials, recording only the essential facts, decision and sentence. Say next section when you're ready, and I'll explain Section 392 next from the Bharatiya Nagarik Suraksha Sanhita 2023 in the same easy, exam-friendly manner. Bharatiya Nagarik Suraksha Sanhita 2023 Section 392. Section 392 Copy of judgment to be given to the accused. What this section is about. Section 392 ensures that the accused is informed of the court's decision by providing a copy of the judgment. It supports transparency and the right to appeal. Simple explanation. After the court delivers its judgment, the accused must be given a copy of the judgment. This helps the accused understand why they were convicted or acquitted and decide whether to file an appeal or revision. Key points. Who gets the copy? The accused person. When? As soon as possible after the judgment is pronounced. Cost. If the accused is in custody, the copy is usually given free of cost, as per rules practice. Why this matters? Ensures the accused knows the reasons and findings of the court. Protects the right to challenge the judgment. Promotes fair procedure. In short, Section 392 guarantees that the accused receives a copy of the judgment, enabling awareness of the decision and access to further legal remedies. Say next section when you're ready, and I'll explain Section 393 next from the Bharatiya Nagarik Suraksha Sanhita 2023 in the same easy, exam-friendly manner. Bharatiya Nagarik Suraksha Sanhita 2023 Section 393. Section 393. Judgment to be translated into the language of the accused. What this section is about. Section 393 ensures that the accused can understand the court's judgment by requiring a translation when the judgment is written in a language the accused does not understand. Simple explanation. If the judgment is written in a language not understood by the accused and the accused requests it or the court considers it necessary, then the court must provide a translation of the judgment in a language the accused understands. Key points. Purpose. To ensure the accused fully understands the decision, the reasons, the conviction or acquittal, and the sentence, if any, when required, especially important when the accused is illiterate or the court's language is different from the accused's known language. Cost. In many cases, especially when the accused is in custody, the translation is provided free of cost, subject to rules. Why this matters? Protects the right to a fair trial. Enables the accused to make an informed decision about appeal. Prevents injustice due to language barriers. In short, Section 393 ensures that an accused is not disadvantaged by language by providing a translated judgment when needed. Say next section when you're ready, and I'll explain Section 394 next from the Bharatiya Nagarik Suraksha Sanhita 2023 in the same easy, exam-friendly manner. Bharatiya Nagarik Suraksha Sanhita 2023 Section 394. Section 394. Court of Session to send copy of judgment to the district magistrate. What this section is about? Section 394 requires the Court of Session to send a copy of its judgment to the district magistrate. This is mainly for official record, supervision, and administrative purposes. Simple explanation. When a Court of Session, Sessions Court, concludes a criminal trial and delivers its judgment, then a copy of that judgment must be sent to the district magistrate, DAM. Why this is done? To keep official government records of serious criminal cases, to help the administration monitor law and order situations, take preventive or corrective administrative action if required, to assist in crime statistics and reporting. Important points to remember. This is an administrative requirement, not a part of the trial itself. It does not affect the rights of the accused or the prosecution. Applies specifically to courts of session, not all courts. In short, Section 394 ensures that the district magistrate is officially informed of judgments passed by the Court of Session, helping in governance and law and order administration. Say next section when you're ready, and I'll explain Section 395 next from the Bharatiya Nagarik Suraksha Sanhita 2023 in the same easy, exam-friendly manner. What Section 395 says? In simple terms, Section 395, Order to pay compensation, gives the criminal court the power to order a person convicted of an offence to pay compensation to cover losses or injuries suffered by victims and related expenses. Key points explained. Compensation from a fine. If a court imposes a fine as part of the punishment, even in a death sentence where a fine is included, the court may direct that all or part of the amount collected as fine be used for. Prosecution costs, what it costs to investigate and prosecute the case. Compensation for victims who suffered loss or injury because of the offence. Compensation to legally entitled persons in case of death under the Fatal Accidents Act. Compensation to an innocent purchaser if stolen property is restored. When there is no fine. Even if the sentence doesn't include a fine, the court can still order the convicted person to pay a specified amount as compensation to a person who suffered loss or injury because of the offence. Compensation at later stages. A similar compensation order can also be made by a higher court, appellate court, high court, or sessions court when reviewing or revising a case. Effect on civil cases. If a victim later files a civil suit for compensation arising out of the same offence, any amount already paid or recovered under this section will be taken into account by the civil court. In everyday language. Purpose: Section 395 helps the court ensure that a criminal conviction not only punishes the offender but also helps the victim recover losses due to the crime. It allows the court to use fines or direct payment from the offender to compensate victims, cover prosecution expenses, and recognize payments already made if the victim sues later in civil court. Bharatiya Nagarik Suraksha Sanhita, 2023, Section 396. Section 396. No appeal in certain cases where accused pleads guilty. Plain English explanation. Section 396 states that when an accused person voluntarily pleads guilty and is convicted on that plea, no appeal is allowed against that conviction. Key points explained. Plea of guilt. If the accused admits the offense in court and pleads guilty, and the court convicts the accused based on that plea. No appeal against conviction. The accused cannot file an appeal against the conviction. Exception: appeal on sentence. Even though the conviction cannot be challenged, the accused may appeal only against the extent or legality of the sentence, if the law allows such an appeal. Purpose of Section 396: to avoid unnecessary appeals when the accused has clearly accepted guilt. To speed up the justice process by making guilty pleas final regarding conviction. To allow limited review only for unfair or illegal punishment, not the finding of guilt itself. Simple example. A person pleads guilty to theft in court. The court convicts and sentences him. He cannot appeal saying, "I am not guilty." But he may appeal if the punishment is illegal or excessive. Bharatiya Nagarik Suraksha Sanhita, 2023, Section 397. Section 397. Powers of the High Court or Sessions Court to call for records. Plain English explanation. Section 397 gives supervisory powers to the High Court and the Sessions Court. They can call for and examine the record of any criminal proceeding of a lower court to check whether the proceedings are legal, correct, and proper. Key points explained. Who can use this power? The High Court or the Sessions Court. Purpose of calling records: to verify correctness of findings, legality of orders, propriety, fairness of proceedings, regularity of procedure followed by lower courts, type of courts whose records can be examined, any inferior criminal court within their jurisdiction, suspension of sentence. While examining the record, the High Court or Sessions Court may suspend the execution of the sentence and release the accused on bail or bond if the person is in custody. Not a full appeal. This is a revisionary power, not an appeal. The court mainly corrects serious legal or procedural errors, not rehear the entire case. Important limitation. This power cannot be used against purely interim orders, temporary or procedural orders that do not finally decide rights. Purpose of Section 397. To ensure justice is done properly. To allow higher courts to correct grave errors made by lower courts. To prevent misuse of power or illegal proceedings. Simple example. A magistrate passes an illegal order without jurisdiction. The Sessions Court or High Court can call the case records, examine them, and correct the mistake. Bharatiya Nagarik Suraksha Sanhita, 2023, Section 398. Section 398. Power to order inquiry. Plain English explanation. Section 398 gives power to the High Court or the Sessions Court, while exercising revisionary powers, to order a further inquiry into a case when justice requires it. Key points explained. Who can use this power? The High Court or the Sessions Court. When this power is used. When examining records under revision, Section 397. If the higher court feels that the case was not properly examined, or evidence was ignored, or the proceedings were unfair or incomplete, what the court can order? The court may direct a magistrate to conduct a further inquiry, or a fresh inquiry into the complaint or case. Scope. This does not mean a full trial again automatically. It is meant to correct serious defects in the earlier inquiry. Purpose of Section 398: to prevent miscarriage of justice, to ensure that cases are properly and fairly inquired into, to correct situations where a case was dismissed or handled without adequate examination. Simple example: a magistrate dismisses a complaint without examining key witnesses. The Sessions Court, on revision, can order the magistrate to conduct a further inquiry under Section 398. Bharatiya Nagarik Suraksha Sanhita, 2023, Section 399. Section 399, Sessions Judge's Powers of Revision. Plain English explanation. Section 399 explains the revisionary powers of the Sessions Judge. It says that the Sessions Judge has the same revision powers as the High Court, but within the limits set by law. Key points explained. Who has the power? The Sessions Judge. Nature of the power. The Sessions Judge can exercise revision powers similar to the High Court under Section 397. This includes calling for case records, examining legality, correctness, or propriety of orders, correcting serious legal or procedural errors. How the power is exercised. The Sessions Judge may exercise the power personally or assign it to an additional Sessions Judge. Limitations. The Sessions Judge must follow the same restrictions applicable to revision powers, including the rule that interlocutory, temporary orders cannot be revised. Relationship with High Court. If a revision application has been decided by the Sessions Judge, the same person cannot approach the High Court again for revision on the same matter. Purpose of Section 399: to decentralize revision powers, reducing burden on the High Court, to allow faster correction of errors at the Sessions Court level, to ensure judicial discipline by preventing multiple revisions. Simple example: a magistrate passes an illegal order. The accused approaches the Sessions Judge in revision. Once the Sessions Judge decides the revision, the accused cannot file another revision before the High Court on the same issue. Bharatiya Nagarik Suraksha Sanhita, 2023, Section 400. Section 400, Power of Additional Sessions Judge. Plain English explanation. Section 400 states that an additional Sessions Judge can exercise all the revision powers of a Sessions Judge when those powers are assigned to him by the Sessions Judge. Key points explained. Who is covered? Additional Sessions Judge. Source of power. The powers are not automatic. They must be specifically given, assigned by the Sessions Judge. Nature of powers. Once assigned, the additional Sessions Judge can hear revision applications, call for records of lower courts, examine legality, correctness, or propriety of orders, pass appropriate revision orders. Same limits apply. The additional Sessions Judge must follow the same legal restrictions as the Sessions Judge, including the rule that interlocutory, temporary orders cannot be revised. Purpose of Section 400: to distribute judicial work efficiently, to reduce delay by allowing additional Sessions Judges to handle revision matters, to ensure smooth functioning of the criminal justice system. Simple example: the Sessions Judge authorize an additional Sessions Judge to hear revision cases. The additional Sessions Judge then lawfully decides a revision against a magistrate's order. That decision is as valid as if passed by the Sessions Judge. Bharatiya Nagarik Suraksha Sanhita, 2023, Section 401. Section 401, High Court's Powers of Revision. Plain English explanation. Section 401 explains the revisionary powers of the High Court. It allows the High Court to correct serious legal or procedural errors committed by lower criminal courts to ensure justice. Key points explained. Wide revision powers. The High Court may exercise all powers of an appellate court while dealing with a revision. It can examine legality, correctness, propriety of any finding, sentence, or order. No conversion of acquittal into conviction. The High Court cannot convert a finding of acquittal into conviction in revision. This protects the rights of an accused person. Opportunity of hearing. No order shall be passed to the prejudice of the accused or any other person, unless they are given a reasonable opportunity to be heard. When revision can be refused. If an appeal lies but no appeal is filed, the High Court may refuse to entertain revision, except in special circumstances. Use in exceptional cases. Revision is meant for grave errors, jurisdictional mistakes, or serious injustice, not for reappreciating evidence like a full appeal. Purpose of Section 401: to act as a safeguard against miscarriage of justice, to allow the High Court to supervise lower courts, to ensure fairness and legality in criminal proceedings. Simple example: a magistrate passes a sentence beyond legal limits. No appeal is filed. The High Court may still correct the illegal sentence using its revision powers under Section 401. Bharatiya Nagarik Suraksha Sanhita, 2023, Section 402. Section 402, Power of High Court to withdraw or transfer revision cases. Plain English explanation. Section 402 gives the High Court the power to withdraw a revision case from a sessions court or transfer it to another sessions judge for proper disposal. Key points explained. Who has the power? The High Court. What the High Court can do. Withdraw a revision application pending before any sessions judge, or transfer it from one sessions judge to another. When this power is used, to ensure fairness, impartiality, or proper administration of justice, it may be exercised on an application by a party or on the High Court's own initiative. Effect of withdrawal. After withdrawal, the High Court may hear and decide the revision itself or transfer it to another competent sessions judge. Purpose of Section 402: to prevent bias or apprehension of bias, to ensure uniformity and correctness in revision proceedings, to allow the High Court to control and supervise revision jurisdiction effectively. Simple example: a revision case is pending before a sessions judge where a party fears unfair treatment. The High Court may withdraw the case and either decide it itself or transfer it to another sessions judge under Section 402. Bharatiya Nagarik Suraksha Sanhita, 2023, Section 403. Section 403, Option of sessions judge in certain cases. Plain English explanation. Section 403 explains what happens when a person files a revision application before both the Sessions Court and the High Court. Key points explained. Only one revision allowed. A person is allowed to file a revision application only once. If the person chooses to file revision before the sessions judge, they cannot later approach the High Court on the same matter. Choice lies with the applicant. The applicant has the option to choose either the Sessions Court or the High Court. Once that choice is exercised, it becomes final. Restriction on multiple revisions. This section prevents filing revision in Sessions Court first and then filing another revision in the High Court for the same order. Purpose of Section 403: to prevent misuse of the revision process. to avoid delay and repeated challenges, to ensure finality of revision proceedings. Simple example: a magistrate passes an order. The accused files a revision before the sessions judge. After losing there, he cannot file another revision before the High Court on the same issue due to Section 403. Bharatiya Nagarik Suraksha Sanhita, 2023 Section 404. Section 404 Power of High Court to transfer cases and appeals. Plain English explanation. Section 404 gives the High Court the authority to transfer criminal cases, appeals, or other proceedings from one court to another to ensure fair and proper justice. Key points explained. Who has the power? The High Court. What can be transferred? Any criminal case, appeal, revision, or other criminal proceeding. Between which courts? From one criminal court to another within the jurisdiction of the High Court. When transfer can be ordered. When it appears that a fair trial cannot be held in a particular court, or there is likelihood of bias, or it is expedient for the ends of justice, or it will conveniently serve parties or witnesses. How the power is exercised? The High Court may act on an application by a party or on its own motion suo motu. Purpose of Section 404: to ensure impartial and fair trials, to remove apprehension of injustice or bias, to protect the credibility of the criminal justice system. Simple example: an accused believes he will not get a fair trial in a district due to local influence. The High Court may transfer the case to another district court under Section 404. Bharatiya Nagarik Suraksha Sanhita, 2023 Section 405. Section 405 Power of Sessions Judge to transfer cases and appeals. Plain English explanation. Section 405 gives the Sessions Judge the authority to transfer criminal cases, appeals, or other proceedings from one criminal court to another within the same Sessions Division to ensure fairness and proper administration of justice. Key points explained. Who has the power? The Sessions Judge. What can be transferred? Any criminal case, appeal, or other criminal proceeding. Between which courts? From one criminal court to another criminal court within the same Sessions Division. When transfer can be ordered. When the Sessions Judge believes that a fair and impartial trial cannot be held in a particular court, or transfer is necessary for the ends of justice, or it will help in the convenience of parties or witnesses, or there is a need for proper distribution of work. How the power is exercised? The Sessions Judge may act on an application by a party or on his own initiative suo motu. Purpose of Section 405: to ensure fair trials at the district level, to allow efficient management of cases within a Sessions Division, to reduce delay and apprehension of bias without involving the High Court. Simple example: a criminal case pending before one magistrate in a district is likely to face bias or heavy backlog. The Sessions Judge may transfer the case to another competent magistrate in the same district under Section 405. Bharatiya Nagarik Suraksha Sanhita, 2023 Section 406. Section 406 Power of the Supreme Court to transfer cases and appeals. Plain English explanation. Section 406 gives the Supreme Court of India the power to transfer criminal cases, appeals, or other proceedings from one High Court or state to another anywhere in India when it is necessary to ensure justice. Key points explained. Who has the power? The Supreme Court of India. What can be transferred? any criminal case, appeal, or criminal proceeding, between which courts, from one high court to another, or a criminal court in one state to a criminal court in another state, when transfer can be ordered, when the Supreme Court believes that a fair and impartial trial cannot be held in a particular state or court, or transfer is necessary for the ends of justice, or there is a reasonable apprehension of bias, or it is required for public interest or safety. Application and hearing. The transfer may be ordered on an application by the Attorney General of India or a party, or by the Supreme Court itself. Parties are generally given a chance to be heard before transfer. Purpose of Section 406: to ensure nationwide fairness in criminal trials, to prevent local influence or pressure from affecting justice, to allow the highest court to intervene when justice cannot be secured within a state. Simple example: a sensitive criminal case in one state faces serious threats, media pressure, or local influence. The Supreme Court may transfer the case to another state under Section 406 to ensure a fair trial. Bharatiya Nagarik Suraksha Sanhita, 2023, Section 407. Section 407, Power of High Court to transfer cases and appeals. Plain English explanation. Section 407 gives the High Court the power to transfer criminal cases, appeals, or other criminal proceedings from one criminal court to another within the same state to ensure fairness and justice. Key points explained. Who has the power? The High Court. What can be transferred? Any criminal case, appeal, revision, or other criminal proceeding, between which courts, from one criminal court to another criminal court, within the jurisdiction of the same High Court, when transfer may be ordered, if the High Court believes that a fair and impartial trial cannot be held in a particular court, or there is a reasonable apprehension of bias, or transfer is necessary for the ends of justice, or it is required for the general convenience of parties or witnesses. How the power is exercised. The High Court may act on an application by a party, or on its own motion suo motu. Opportunity of hearing. Normally, the parties are given a chance to be heard before the transfer order is passed. Purpose of Section 407: to safeguard the right to a fair trial, to remove bias, pressure, or local influence, to ensure confidence in the justice delivery system. Simple example: an accused fears local influence in a district court. The High Court may transfer the case to another district court within the state under Section 407. Bharatiya Nagarik Suraksha Sanhita, 2023, Section 408. Section 408, Power of Sessions Judge to transfer cases and appeals. Plain English explanation. Section 408 empowers the Sessions Judge to transfer criminal cases, appeals, or other proceedings from one criminal court to another within the same Sessions Division, to ensure fairness and proper administration of justice. Key points explained. Who has the power? The Sessions Judge of a Sessions Division. What can be transferred? Any criminal case, appeal, or other criminal proceeding, between which courts, from one criminal court to another criminal court within the same Sessions Division, when transfer may be ordered, if it appears that a fair and impartial trial cannot be held in a particular court, or transfer is necessary for the ends of justice, or it is required for the convenience of parties or witnesses, or proper distribution of judicial work is needed. How the power is exercised. The sessions judge may act on an application by a party or on his own initiative suo motu. Opportunity of hearing. Normally, the parties concerned are given an opportunity to be heard before the transfer order is passed. Purpose of Section 408. To ensure fair trials at the district level. To prevent bias or apprehension of injustice. To allow efficient management of cases within a sessions division without approaching the High Court. Simple example. A criminal case is pending before one magistrate where there is fear of bias or heavy backlog. The sessions judge may transfer the case to another magistrate within the same district under Section 408. Bharatiya Nagarik Suraksha Sanhita, 2023 Section 409. Section 409 Withdrawal of cases and appeals by sessions judge. Plain English explanation. Section 409 gives the sessions judge the power to withdraw a criminal case or appeal from any court subordinate to him and either hear it himself or transfer it to another competent court. Key points explained. Who has the power? The sessions judge. What can be withdrawn? Any criminal case or criminal appeal pending before a court subordinate to the sessions judge. What the sessions judge can do after withdrawal. Hear and decide the case or appeal himself or transfer it to another competent court within his jurisdiction. When this power is used for proper administration of justice, fair trial, or efficient distribution of judicial work. Nature of power. This is an administrative and judicial power meant to ensure smooth functioning of courts under the sessions judge. Purpose of Section 409. To allow the sessions judge to control and supervise subordinate courts. To prevent delay or injustice. To ensure cases are handled by appropriate courts. Simple example. A sessions judge finds that a particular court is overloaded or unable to conduct a trial efficiently. He may withdraw the case and either try it himself or transfer it to another court under Section 409. Bharatiya Nagarik Suraksha Sanhita, 2023 Section 410. Section 410 Withdrawal of cases by Chief Judicial Magistrate. Plain English explanation. Section 410 gives the Chief Judicial Magistrate, CJM, the power to withdraw any criminal case from a magistrate subordinate to him and either try the case himself or transfer it to another competent magistrate. Key points explained. Who has the power? The Chief Judicial Magistrate. What can be withdrawn? Any criminal case pending before a magistrate subordinate to the Chief Judicial Magistrate. What the CJM can do after withdrawal. Hear and decide the case himself or transfer the case to another competent magistrate under his control. Purpose of withdrawal. To ensure fair trial, proper administration of justice, speedy disposal of cases, or balanced distribution of judicial work. Nature of power. This is both an administrative and judicial power, meant to supervise and manage subordinate magistrate courts effectively. Purpose of Section 410. To maintain efficient functioning of magistrate courts. To prevent delay, bias, or improper handling of cases. To ensure that cases are tried by the most appropriate court. Simple example. A case before a magistrate is getting delayed or improperly handled. The Chief Judicial Magistrate may withdraw the case and either decide it himself or transfer it to another magistrate under Section 410. Bharatiya Nagarik Suraksha Sanhita, 2023 Section 411. Section 411 Making over or withdrawal of cases by judicial magistrate. Plain English explanation. Section 411 gives a judicial magistrate the authority to make over, assign, a criminal case to another competent magistrate or withdraw a case from a magistrate subordinate to him in accordance with law. Key points explained. Who has the power? A judicial magistrate who has authority over subordinate magistrates. What the magistrate can do: make over, transfer, a case to another competent magistrate, or withdraw a case from a subordinate magistrate. What happens after withdrawal? The judicial magistrate may try and dispose of the case himself or transfer it to another competent magistrate. Purpose of exercising this power: to ensure fair trial, speedy disposal of cases, proper distribution of judicial work, and effective court administration. Nature of the power. This power is administrative in nature, but it directly affects judicial proceedings. It must be exercised according to law and judicial discipline. Purpose of Section 411: to help magistrate courts function smoothly and efficiently, to avoid delay or improper handling of cases, to ensure cases are heard by the most appropriate magistrate. Simple example: a magistrate's court is overburdened with cases. The judicial magistrate may transfer some cases to another magistrate or withdraw and handle them himself under Section 411. Bharatiya Nagarik Suraksha Sanhita, 2023, Section 412. Section 412. Reasons to be recorded. Plain English explanation. Section 412 requires that whenever a criminal court passes an order under the transfer or withdrawal provisions, the court must record the reasons in writing for making such an order. Key points explained. Mandatory recording of reasons. Any order made under the relevant transfer-withdrawal sections, such as sections 406 to 411, must clearly state why the order is being passed. Applies to all concerned courts. This obligation applies to the Supreme Court, High Courts, Sessions Judges, Chief Judicial Magistrates, and Judicial Magistrates when they exercise transfer or withdrawal powers. Ensures transparency. Writing reasons ensures that the decision is not arbitrary. Parties understand the basis of the order, and higher courts can review the decision if required. Part of fair procedure. Recording reasons is an important part of natural justice and fair trial principles. Purpose of Section 412: to promote accountability and transparency in judicial orders, to prevent misuse of transfer or withdrawal powers, to ensure confidence in the criminal justice system. Simple example: if a sessions judge transfers a case from one court to another, he must write the reasons, for example, likelihood of bias or convenience of witnesses. A transfer order without recorded reasons would be improper under Section 412. Bharatiya Nagarik Suraksha Sanhita, 2023, Section 413. Section 413. Execution of orders of transfer. Plain English explanation. Section 413 explains how transfer orders passed by higher courts are to be carried out. It ensures that when a case or appeal is transferred, the order is properly implemented by the courts concerned. Key points explained. When this section applies: when a criminal case, appeal, or proceeding is transferred under orders of the Supreme Court, High Court, or Sessions Judge. Duty of courts. The court from which the case is transferred must promptly send all records and documents to the court to which the case is transferred. Obligation to comply. The transfer order is binding. Subordinate courts must follow it without delay or objection. Ensures continuity. The receiving court proceeds with the case from the stage at which it was transferred unless directed otherwise. Purpose of Section 413: to ensure smooth and effective implementation of transfer orders, to avoid confusion, delay, or jurisdictional disputes, to maintain continuity and efficiency in criminal proceedings. Simple example: a High Court transfers a criminal case from District A to District B. Under Section 413, District A Court must immediately send the complete case file to District B Court. District B Court then continues the trial according to law. Bharatiya Nagarik Suraksha Sanhita, 2023, Section 414. Section 414: Notification of substituted sentences. Plain English explanation. Section 414 deals with situations where a sentence passed by a criminal court is later changed, substituted by a higher authority or court. It explains how and to whom this change must be officially communicated. Key points explained. When this section applies: when a sentence passed by a criminal court is commuted, reduced, or otherwise substituted by a lawful authority or court. Duty to notify. The authority or court that substitutes the sentence must formally notify the court which originally passed the sentence and the officer in charge of the jail or place of custody if the accused is imprisoned. Purpose of notification: to ensure that the new sentence is correctly carried out and the earlier sentence is not wrongly enforced. Binding effect: once the substituted sentence is notified, the jail authorities and courts must act according to the new sentence only. Purpose of Section 414: to ensure proper execution of modified sentences, to avoid confusion or illegal detention, to maintain accuracy and coordination between courts and prison authorities. Simple example: a person is sentenced to 5 years imprisonment. Later, the sentence is reduced to 2 years by a competent authority. Under Section 414, the change must be officially communicated to the trial court and jail authorities, so the prisoner is released at the correct time. Section 415: Appeals from convictions. Plain English explanation. Section 4